Resolving high-stakes financial disputes during a divorce requires a rigid, predictable procedural framework to function correctly and fairly. The court faces a constant balancing act. It has a legal mandate to achieve a fair distribution of marital assets, but it must do so using finite judicial time and resources. This section of the syllabus outlines the legal authority for those financial remedies. Part 9 of the Family Procedure Rules 2010 acts as the definitive legal blueprint for managing these proceedings. Part 9 operates as an active filtration system designed to compel early transparency and drive the parties toward settlement. Practice Direction 36N moves this entire process into a mandatory digital environment. Firms must now register and start cases via the secure online portal. Operating as a single family court, the system relies on this technology to manage the administrative load of financial cases across the jurisdiction. The procedure draws in fragmented, contested marital assets and outputs them into a standardized digital interface on the online portal. Part 9 uses this technology to narrow the issues in dispute long before a judge is required to give a final ruling. Phase 1 involves initiation and the pre-application protocol. Before any application can be issued, parties must attend a Mediation Information and Assessment Meeting, or MIAM, unless a specific legal exemption applies. Once mediation is attempted or bypassed, the mechanical initiation of the case takes place entirely through the PD36N online portal. The legal claim begins with Form A. This serves as the mandatory notice of intention to proceed with an application for a financial order. At this stage, practitioners must account for a critical procedural hazard known as the remarriage trap, governed by Section 28(3) of the Matrimonial Causes Act 1973. A party who remarries before formally issuing their financial application is barred from applying for capital or property orders against their former spouse. Issuing Form A past this threshold allows the timeline to advance into the formal data gathering phase. Proper initiation establishes the chronological threshold that preserves a client's right to access the court's jurisdiction. Phase 2 introduces the mechanism of mandatory disclosure. Under the Silex Code of Conduct, practitioners have a duty of full and frank disclosure. Both parties must reveal all assets and liabilities to the court and to each other. The legal standard in Livesley v. Jenkins confirms that if an order is based on incomplete information, the court can set that order aside. Form E is the primary financial questionnaire used to enforce that disclosure. The timing is strict. Both parties must exchange and file Form E not less than 35 days before the first appointment. This document requires the comprehensive account of all resources, including attached payslips, mortgage statements, and detailed property valuations. Without the raw data extracted by Form E, the court cannot determine a fair division of resources. Phase 3 brings the parties before a judge at the first appointment, or FDA. The first appointment serves as a case management hearing. The judge determines what further information is needed and directs the instruction of experts and asset valuations. To streamline this stage, the Financial Remedies Court issued an efficiency statement aimed at reducing duplicative paperwork. This statement mandates the use of joint documents, such as Form ES-1 for chronologies and Form ES-2 for a consolidated schedule of assets and liabilities. Instead of submitting conflicting spreadsheets, both legal teams work on a single joint version of the ES-2, presenting the applicant's view and the respondent's view side by side. If the parties agree on all case management directions 14 days prior to the hearing, they can use the accelerated procedure, bypassing the need for a personal court attendance. Parties must also file Form H at this stage, providing an estimate of legal costs to ensure they remain proportionate to the total dispute. The FDA consolidates unilateral posturing into a court-managed roadmap toward resolution. Phase 4 is the Financial Dispute Resolution Appointment, or FDR. This is a mandatory, privileged arena explicitly designed for negotiation rather than fact-finding. The FDR operates on a without prejudice basis. No offers or admissions made during this meeting can be repeated at a later date. After reviewing the offers, the judge provides a neutral indication of the likely outcome if the case proceeds to a final trial. Because the judge has seen privileged settlement offers, the FDR judge can have no further involvement in a contested final hearing for this case. This insulated environment allows parties to explore realistic concessions and drive early settlement without fear of those offers being used against them at trial. Phase 5 is the final hearing, the destination for cases that fail to settle. Once an FDR fails to produce an agreement, both parties must file and serve open proposals outlining exactly what orders they are asking the court to make. This critical breakdown in negotiations leads inevitably to the final hearing. Preparing for this stage requires strict compliance with Practice Direction 27A for trial bundles, demanding exact chronological pagination and organization. The court imposes administrative limits on the trial evidence. A standard bundle is restricted to a single file, capped at 350 pages, forcing the parties to distill their arguments to the essentials. A final hearing represents the end of the filtration system, requiring total administrative precision to allow a judge to impose a binding financial order. The vast majority of financial remedy cases exit the timeline early as negotiated settlements. When an agreement is reached, it is codified as a consent order and submitted through the digital portal. A draft consent order must be paired with Form D-81, a statement of information that summarizes the financial impact of the agreement. The court must review these documents to ensure the terms are fair in all the circumstances. The judge will only approve the order if the terms are appropriate for the case. To maintain efficiency, legal practitioners use standard order precedents drafted by the Family Division when writing these agreements. The strict procedural rigor of Part 9, powered by the digital portal, converts adversarial disputes into structured, court-approved resolutions.